Hi, my dragons. This is Lecture 2, Part 3. Back to my den. Okay, so we are on slide 18 of this intro PowerPoint, and you'll see a layout of the differences between psychology and law. And it has, all the differences there. I put that in there because it makes a great essay question for you to explain all of those things that we've talked about in those differences. So that's for your FYI there. So historically, how has psychology been used in law? Well, even though we've had some big differences between us, the law has on occasion used psychology in the law, especially for different types of decisions, okay? So sometimes they've had to find common ground. So one of the first contributions of psychology in law was with Justice Brandeis, Justice of the Supreme Court. He would cite in his dicta all the time different types of statistical evidence, social science, things to buttress his legal decision, and we call that the Brandeis Brief, okay? So people were used to seeing that from Justice Brandeis, and you can look in any of the cases that he has written in, and you'll see in the dicta that he uses empirical research. Go imagine, okay? Hugo von Munsterberg wrote On the Witness Stand in 1908, and so this was a really early writing and a really good affirmation of what eyewitness testimony. So here's someone who saw early on that eyewitness testimony and accuracy were two things that had to be considered by the court. He had a good challenge about it, saying that it was not accurate all the time, but there was no empirical data cited. Okay, keep in mind that it was 1908, but it was the first to talk about it. And Edward Robinson in 1935 wrote Law and Lawyers, where he looked at behavioral science as being a possible tool to help the law. And every legal problem, he said, was essentially a psychological one. I couldn't agree more. And in 1897, Justice Oliver Wendell Holmes, a Supreme Court justice, started saying things like, hey, the law is going to be evolving, and we're going to have to include emerging, he didn't use the word technology, but emerging technologies like economics and statistics and things like that in the future for the law. So in the 1930s and 40s, research on how trial evidence was processed and evaluated by jurors was starting to be introduced. And by the 1950s, we were seeing social science and research in the courtroom, especially during civil rights, to try and challenge laws and civil rights cases. So civil rights cases really gave a great time to be using social science and research in the court. So the most historical example of that would be in civil rights, like we just mentioned. And in 1896, we had the Plessy versus Ferguson case. And in that case, there was, you probably heard of this case, it's really famous. It established segregation in the United States, separate but equal. So during that time, there was a man who was riding on a train, and he was biracial, and he was kicked off the passenger part of the train and told to ride in the open part of the bed part, like a bed, train bed part of the train, because that's where people who were not white would go. And he objected, saying that he was biracial and he shouldn't be doing this. And the court ruled against him and said that, this is separate but equal. The court used the term separate but equal. You still can ride in the train, but you have to be separate but equal. And actually in the dicta, remember I was telling you in the dicta is really the part where you get to see what's on the minds of the justices as they rule in these cases. And it kind of an pretty insulting thing that they wrote. One of them said, if anyone thinks that this is, they wanted to use the word discrimination, but they didn't use the word discrimination, that this is unjust, I think maybe they used, then it's not on white people or even the law. It's basically, what they basically said was it was just a hang-up that black people had because they were viewing it this way, and really that's not the case. Okay, I don't really see how you could view it any other way. So, as we talked about, one of the ways that psychology and law mistrust each other is because psychology is fast moving. Okay, you do research, you find a new finding, it challenges the reliability and the validity of former pieces of research. So we overthrow it, and now we have new theories. And in the law, it takes a long time. Okay, the law is very slow and it's precedental, so it takes a long time, one precedent versus another. So there were a lot of cases that challenged separate but equal, Plessy versus Ferguson, but it didn't overthrow it. And there were some really outrageous things that were happening in the United States that you think, oh my God, what is it going to take to overthrow this? So I want to give you two cases. They did not overturn Plessy versus Ferguson, but it gives you an idea of how outrageous some of the things were that people had to live with through segregation from a legal standpoint, that it was, it made it to the Supreme Court, but didn't overturn, which is, today is crazy. Sweat versus Painter in Texas, who was an individual who wanted to go to law school, okay, and he applied and was accepted, okay. He was African American, but they didn't know that when they accepted him. And then when they found out that, oh my God, we admitted an African American, what are we going to do? They couldn't unadmit him. So what they did was they said, you can come here, but we're going to build a separate law school. It'll be equal, but it'll be separate. And so he sued and said, it won't be equal. It may be separate, but it won't be equal. So, won their case, but didn't overturn Plessy. Crazy. In McLaren versus Oklahoma, talk about indignities. This was a terrible case. So McLaren was a young man who already had a master's degree in education and wanted a doctorate in education. So applied to University of Oklahoma. Same thing. They didn't realize that it was an African American, was accepted, and then realized it was an African American, and made him do a whole bunch of different things that were really chipped away at his dignity. Like, they wouldn't let him in the classroom at the same time because in Oklahoma you couldn't teach black people and white people together. So they wouldn't let him in the classroom. So he had to sit outside the classroom, at a separate desk outside the classroom with a little roped off thing that said reserved for coloreds on it. Okay? Wouldn't let him eat in the cafeteria at the same time. Had a whole different table in the cafeteria, and sometimes had to eat at a totally different time than anybody else that was in there. And he had a special seat in the library. Okay? Separate, but equal. No, it wasn't even equal because of what they were doing to his dignity. So there's another case that didn't overturn Plessy versus Ferguson. So 60 years later, 60 years, this is how slow the law is. 60 years later, you have Brown versus the Board of Education of Topeka, Kansas, and that would be the one to overturn Plessy versus Ferguson. It was argued by a young lawyer who basically became the first African American to sit on the Supreme Court. Okay, and Thurgood Marshall. So he argued the case for Plessy versus Ferguson, and what he did was he used psychology, a research psychology. So he had two of his friends at New York University, two professors, Dr. and Dr., Mr. and Mrs. Okay, that was bad. Kenneth and Mamie Clark. And they did the famous doll study. So the doll study, I'm going to put a link up so you can see what that is. The doll study, they went around to all these different schools, and they had children, and they had a black doll and a white doll, and they said, which is the good doll, which is the doll you want to play with, and which is the doll that's most like you. And what happened was very sad. Kids were picking the black doll as the bad doll, and the black doll is the bad doll, and the black doll is, not as good as the white doll. And the result of that study, as Thurgood Marshall argued, was that segregation sets kids up to learn that black is bad and white is good, and that it puts them into a cognitive framework, whereas they spend their whole lives thinking that they are bad, and the Caucasian kids, they end up thinking that they're good or better. And neither of those is true, and it was an insult to the 14th Amendment. All people created equally, equal application of the law, and that is the one that overturned Plessy versus Ferguson. Okay, unfortunately, that legacy is true today as well, and I'm going to show you. I'll put the video link up. It'll be your forum assignment for this week, so you can watch it and tell me what you think. So because of that case, it was footnoted in the Supreme Court, and then we saw more people using research to bolster their arguments in front of the Supreme Court, and the use of amicus brief, which is full of research, as you well know. So there you go. Or maybe you didn't do an amicus brief. So an amicus brief is a friend of the court brief, and it's full of scientific information that places submit to the court so that they can help make their decision. So to this day, we see more use of that in the Supreme Court and other courts. So that's a really cool thing that came out of that. In 1966, Calvin and Zeisel did a book called The American Jury, and what they did was they were in Chicago and they looked at all of the cases that Chicago had been hearing for a long time period, and it covered all kinds of really cool things about how juries make decisions. I have that in my office as well. It's a really foundational piece of research, and it covered things like what the judge knew and the jury didn't know, what the jury took into account that was not really evidence, but they took into account anyway because it was emotional stuff that swayed their opinion. So it was really information, really good information, and it's a totally big foundational compendium of how juries make decisions. This led to new fields within forensic psychology, like jury consulting and trial consulting, and that sort of thing. In 1969, the American Psych Law Society, which is Division 41 of the APA, was established with 4,000 members, okay? And 10% of them were doing basic research. The number one book in forensic psychology, no, is not the Journal of Forensic Psychology, it is Law and Human Behavior. So Law and Human Behavior is the leading publication in the field of forensic psychology, and it is dedicated to uniting psychology and the law, and also other fields like sociology, criminology, criminal justice, psychiatry, all those other areas, economics. The National Science Foundation also helped advance forensic psychology by making grants and funding available with an intent to make the field better. So that was really cool. And then the American Board of Forensic Psychology certifies practitioners for forensic psychology all over the country. You can be certified once you graduate and get your master's degree. And they offer schools and stuff recommend schools and stuff for JD, PhD, all that kind of stuff too. We also have a new journal, Psychology, Public Policy, and the Law. And there's a whole bunch of new journals that came out after that. That looks at legal cases, okay? So we're going to stop there before I get into some particular cases of psychology and the law. And hopefully we'll do the rest in person, because I really want to tell you some really cool stuff about these cases. So do that, and do the thing on the forum, and hopefully I'll get my results by Friday, which will put me in class by Monday. But if it comes on Monday, then I'll see you on Thursday. Eek. I miss you guys. So we'll see you soon, and remember, it's a great day to be a dragon.